This account was created to provide information on how current immigration laws apply to certain factual scenarios. There are many, I suspect, who are worried about their immigration situation, but they're not sure if they should speak to an immigration attorney. Keep in mind, and I cannot stress this enough, that immigration law is unbelievably fact-specific. So even if you think that your situation is nearly identical to one of the ones that I go over here, you still need to speak to an immigration attorney personally. Even the smallest factual changes can make a big difference in the outcome. That said, this is not legal advice. I'm hoping this will merely help educate people as to how the immigration laws work, because I know there are a lot of anxiety exists in certain immigrant communities. Also, immigration laws and procedures will likely change quite a bit in the months to come. So what might be accurate and current at the time of this recording very well could change in the weeks to come, maybe even tomorrow. All right, so I've brought a colleague in today to talk about some things that are related to immigration. Tuan is an attorney that I've worked with on a number of occasions with clients. We've collaborated specifically in situations where the client has criminal convictions that are going to affect the overall immigration case. So what Tuan does is goes into the criminal court and tries to get those convictions essentially taken off the client's record so that we can move forward with the immigration case. So we want to talk about that, what situations those would come up in, and how we handle those. So Tuan, to start, let's say that that a person is married to a U.S. citizen. They are eligible to do a 601A waiver, but we notice that they have, let's say, a drug possession conviction from, years ago, maybe 10, 15 years ago, something like that. So how do you approach that situation? What do you do, basically?
Okay, so in a scenario like that, first thing we would do is we would pull the files and then look over the record to see if the person was advised of their immigration consequences when they entered the plea for that conviction. So if they, weren't advised, then we can vacate based on that information. We also look to see if the court had advised them, or if their prior attorney had advised them as well too. So there's a few ways to go ahead and try to vacate a conviction.
Okay, so and when you're talking about advising the client, basically this is whether the court or whether their attorney advised that if they pled guilty to this charge, that it could affect their immigration future. That's what you're saying?
Correct, yeah. So when you enter in a plea under California law, you have to be advised of your immigration consequences. Mm-hmm. You have to be, it's either by the court or by your prior attorney. That's generally what happens. Sometimes in rare cases, like really old cases in the 90s, if you have a really old conviction, there was no advisement at all. It's possible if the record doesn't show it, then that's like an easy way to vacate as well too.
Now, in more recent cases though, it would be more common for the court to say something on the record, right? That this individual has been advised that immigration consequences might occur and that sort of thing, right?
Right. So yeah. So I guess the whole thing is that there is the law's been around forever. So the court has to advise you before you take the plea, but sometimes in the record it doesn't show that there was any advisement at all. So like you can pull the record, the docket, or like the court. The court docket or the transcript, and it'll show that they advised you or not.
It'll just say that this person's been advised, but we don't know what the advice was.
We don't know what the advisement is. So a lot of times you have to pull the court reporter's transcript. So if the case is really old, it's not going to exist anymore. Mm-hmm. So that's one way to try to vacate. Another way would be if the prior attorney had advised the individual of the immigration consequences, we would have to pull the old attorney's file and look at their notes to see if there's any notes about advisement.
So they're in, like, basically their file that they still have in their office, because
Right.
this wouldn't be part of the court record in that situation. Okay.
Right, yeah. And then there's a new law that says that if you didn't understand your immigration consequences when you entered the plea, then you can vacate the conviction as well too.
Okay.
So there's multiple ways, yeah.
And I know that, we have, I'm sure you've dealt with this too, but, a client comes in and says, well, I got that conviction expunged. So, that shouldn't affect my immigration case. So what's the difference between what you're doing and kind of a standard issue expungement?
So with an expungement, immigration doesn't recognize it.
Mm-hmm.
So it's the reason why they don't is because it's for rehabilitative purposes.
Right.
So
you still committed the crime, basically.
Right,
you just did some classes or did this or that, and so they
right.
dismiss it or whatever, but immigration court still views that as, no, you did this crime.
Right, it's still conviction for immigration. So what we do is it's based on a legally invalid conviction or unconstitutional conviction. So there was some kind of legal invalidity in the case, usually because the person was advised.
Yeah.
So it would vacate the conviction completely, entirely. It's
Right.
not because you did your classes and you stayed out of trouble, you paid your fines. It's not the same thing.
Yeah.
Here it's because when they took the plea was, they weren't advised about the immigration consequences of the plea.
Right. So it violated their constitutional rights.
Right.
Therefore, this conviction
it's not legally
didn't
valid.
happen.
Right. Yeah.
Essentially, is what we're able to argue when it comes to the immigration consequences.
Right.
So what does that? I mean, what does that look like? So you've pulled, you go in and you pull the record and you kind of review either the court transcripts or the docket report, and then what's the next step that you do to kind of move that process forward to vacate the conviction?
Okay, so once we pull the files and we review it, so we'll have to go over with the client, what happened during the case.
Mm-hmm.
So if they were advised, by the court, if the attorney had advised them, and if the attorney had provided them any options, like different options of if they didn't take the plea, then was there any alternative pleas?
Mm-hmm. And
if there was, then what was it? And then why didn't it take it? And then the last one is if they understood, like when they took the plea, that they were going to get deported. Were they told that, and then did they understand that? Because a lot of times they're told really quickly at the day of the hearing, and it's just sign there.
They've already made up their mind. I'm pleading guilty to this.
Just sign it, and then they just sign the form.
Yeah.
Entering the plea. Yeah. So that's what happens usually.
Okay. So then you file. What are you filing with the court? It's a motion to reopen or a motion to vacate, or what does that look like?
It's a motion to vacate the conviction.
Okay.
So it's drafted. We draft it basically based on whatever the facts of the case are.
Mm-hmm.
Yeah, it's not a form. They call it on a pleading paper.
Okay.
And then from there, it's set for a hearing, and then we usually have a hearing on the motion. Usually 30 days out. I mean,
Okay.
we can get an earlier hearing if necessary, but I mean, the DA might oppose it or they might object because the time is not enough for them to file a proper opposition.
Okay.
Or to review the case at least.
Okay, so then the DA is on the other side of this. They file an opposition, or maybe they don't sometimes. It kind of, how does that work?
A lot of times I would say 50-50, they'll file an opposition. Even if they don't file an opposition, they can oppose it the day of and argue the motion at the hearing. And then we'd have to be ready to go. So we don't even, it's better for them to file an opposition so we can file a reply.
Yeah.
But if they don't, then we have to be ready to go on, to argue the motion right there and there.
Yeah.
Yeah, based on what their opposition is going to be.
And then does the judge typically, I mean, I'm sure it depends to some degree, but does the judge typically make a decision at that hearing, or do they say, okay, I'm going to review everything, I'll let you know in 2 weeks? Or
it depends.
They
can make a decision at that hearing. They could set it for another hearing, for an evidentiary hearing.
Okay.
Bring the client in.
Mm-hmm.
They may have to testify. So there's multiple ways that can go about. I mean, even on the first hearing, there can be a continuance because the DA is not ready.
Yeah.
There's a lot of things that can happen. Right.
Okay.
Yeah.
So I know that we've done cases together involving San Bernardino County, Riverside. I don't remember what that one was last year, if it was Orange County.
It was
or...
Orange County.
Okay.
Yeah.
There's also LA County. Do you do stuff in San Diego or in Northern California, or is it mostly in kind of...
I do stuff in San Diego as well too, and then I've done some stuff from the Bay Area as well too.
Okay. I think I even maybe sent you one for Northern California.
Right.
So I mean, obviously, it depends on the DA you're dealing with. It probably depends on the judges and the county. So what things do you see in terms of differences on how the different jurisdictions handle these motions to vacate?
I think a lot of from my experience, the jurisdiction does matter. So the DA's office is generally more lenient in LA County, somewhat lenient in Orange County, but fairly strict in San Bernardino and Riverside County.
Okay.
The Bay Area, they're pretty lenient as well too, for the most part.
So they won't push back so much, or they might not even oppose it, or they might, what does it mean to be like lenient, I guess? What do you see?
Lenient means if they'll oppose it or not. So, one of the big factors is how old the conviction is and how serious it is. So if it's like more of like a drug charge, then the chances are really high to get it vacated.
Okay.
But like if you're in San Bernardino County or Riverside County, they're still fighting those.
Yeah.
So you'll have a heavily contested hearing. Orange County, it could be contested if you have multiple. So if you have one, then the chances is really high. Even if you have multiple, you could still get it vacated.
Okay.
It's not a completely, you're not like, it's not one of the things where it's where for sure you're gonna lose. That's the thing. You can still.
So they're looking at kind of the whole picture, not
Right.
just, okay, you're asking to get this one vacated. They're probably looking at, okay, let's see your whole rap sheet.
Right. How many do you have?
Wow, this is a lot. We're not going to agree to,
Right,
we're not
yeah.
going to agree to let you vacate this. We're going to fight this, that
Right.
type of thing. Okay.
Right, that type of thing. Yeah. So if you have like one, then obviously the chances are a lot higher. Assuming that the conviction is on the less severe side. So if you have like one but very severe, like a domestic violence or something, like you get 2 years, something like that, and you just have one, but still that's a very severe.
That's one that's really
that's gonna be a really tough case to make.
So I wanted to ask about that. So what other kinds of there are plenty of types of convictions that can really cause problems for immigration. Firearms offenses, domestic violence, absolutely. Talk about some of those different types of convictions and how those are viewed by the court and the DAs when it comes to trying to vacate them.
With the DAs, when it's a severe conviction, they don't want to vacate.
Mm-hmm.
Like pretty much, you're running into a wall right away. You already know the minute that you try to do it. But this kind of area of law is more like if you kind of don't have a choice. Like if you want to stay in the U.S., you have to try to vacate it.
Yeah.
Yeah.
So, which ones are considered more? You mentioned domestic violence. What other ones would kind of rise to that similar level?
For the most part, anything that's has to do with a violent crime. Like
Okay.
anything that involves violence for sure is going to be more difficult.
Mm-hmm.
Firearms is more difficult.
Mm-hmm.
I think the ones that are the more easy is always drug possession under the influence of drugs, or like low level theft. So like if you're talking about like some sort of like robbery, then that's going to be hard.
Yeah.
Yeah, right off the bat, that's hard because it involves violence.
Okay. Yeah, that makes sense. So let's say that the judge rules in favor of you and your client. Okay, so the judge, agrees to vacate. What are the things that can happen what are the things that can happen after that? Does the case just completely go away? Do you have to plead to a new charge? How does that all kind of look?
So if it's kind of like on the minor side, chances are they'll just dismiss the case. So once they vacate. Sometimes we can get into a deal with the DA before the hearing. So we'll just enter into a new plea after the motion is granted.
Mm-hmm.
So they'll either do the new plea there, or they'll set it for another hearing for the new plea. And most of the time for like a more serious case, more serious charge, they'll probably put it back on the trial calendar. So you're basically, once you vacate, you're going back into the same position you were before you take the plea. So the case can go forward Will it go forward? It's hard to say, depending on how old it is. If it's fairly recent, it'll probably go forward.
If it's going back to like a drug possession scenario, if the court vacates the drug possession, but let's say they're going to make you take a new plea, what are some of the things that that you look at in terms of alternate pleas?
Okay, so one of the new pleas that's available is public nuisance.
Okay.
Public nuisance or accessory after the fact.
Okay.
Yeah, those are the two most common alternate pleas for possession or under the influence of drugs.
And those don't result in immigration consequences because those are viewed as lesser offenses.
Well, accessory after the fact could be, so it really depends.
Yeah.
The safer way, I think, would be to do public nuisance.
Yeah.
Right.
Because that could be anything.
Right.
That could be loitering, basically, or something like that.
Yeah. So the only problem right now is that a lot of these, it's always changing. So accessory after the fact was more the more common one before that people would plead to, but now there's new law that says that they can look at the old charges.
Right.
And
determine that this actually involved drugs and possession and stuff like that.
So it's not really that clean. So I mean, unless that's your only choice, then okay. But if there's other choices, then you would want to take something else.
Yeah.